for the leave to appeal, Afriforum versus Economic Freedom Fighters and others, EQ4 of 2020.
May it please you, Judge, I appear with my learned friend in pupillage, Mr. Christopher Burke, who has a yet worse fate than the rest of us today. He's sitting an exam, so he isn't physically or virtually with me, but he has assisted me. And if I may, through you, take the opportunity of greeting my colleague, Mr. Kasuboto. Thank you.
Thank you. Thank you very much.
Thank you, Judge. Kasuboto, appearing for all three respondents and with the court's leave. Same courtesy, Mr. Gauntlet.
Thank you very much. Thank you, gentlemen. Before we start, if I can just indicate that the reason we're starting so early is partly because I'm involved in another hearings from 10 o'clock. And therefore, I would hope that we will try to keep to that time. I've read both your submissions, and thanks very much. They've been very useful. And so I would suggest that we don't repeat what's already set out in the heads. If we could touch on the pertinent issues. And in that regard, Mr. Gauntlet, I wonder whether it would not be best to deal firstly with the first song, the song which was sung by Dr. Ndlozi, before we deal with all the others. And I'm isolating it because it seems to me, even during the hearing, there was very little said about that song.
Thank you, Judge. With your leave, Judge, though, might I deal before that first with the important issue which my learned friend, Mr. Kasuboto, raises, and which is really preliminary, and that is that we all get correct what is now the appropriate test in granting leave to appeal. We need to get that clear, and we differ on it before we turn to the question of whether that test is met in relation to the first song and or the second song.
Okay.
The point of difference, Judge, you would have seen is ventilated on in the written submissions. So again, taking my cue from you, I'm not going to try to read out everything which is in those submissions. I ask you, however, to note the following. Firstly, the respondents adopt as their approach to the question of the test the Fair Trade Independent Tobacco Judgment, which they have as footnote 1 in their written submissions, a judgment of the provincial division. We, in our heads of argument, have drawn attention to two Supreme Court of Appeal decisions to which the respondents don't refer. And in the Supreme Court decisions, which we reference in our footnote 2, it said very simply that what is required is that you show a sound, rational basis. Now, why this is important is if you look at what is argued for the respondents in paragraph 8, finally, of their written submissions, they say that appeals are not there for the taking simply because a disgruntled litigant wants another court to have another look at the matter. It's impermissible even if another court might come to a different conclusion. A degree of certainty about the fate of the appeal must be established. Judge, it's very important that you determine with respect whether you're going to be bound by the Supreme Court of Appeal formulation or not, because if one is, then one doesn't need to, with respect, flounder around with paraphrases. We know it's not a question of having other bites at the cherries. It's not a question of a disgruntled litigant wanting, seeing if another court might come to a different conclusion. It's whether there is a sound, rational basis to contend that another court would see it differently. That's not the same as certainty. And this is where, with respect, there's a fatal flaw in the entire approach for the respondents in this morning's application. They say to you relying on the lower authority, that there has to be what they call a degree of certainty. With respect, there does not. What there has to be is a reasonable prospect. If one was going to introduce in section 17 a degree of certainty, there would be a formulation which indicates that. But on the spectrum between mere speculative possibility and certainty, an intermediate position has been adopted, and that is that the court decides that there's a sound rational basis. It's not open and shut. The case may be difficult, as this case is difficult. It involves important issues which are not easy to resolve. But with respect, we'll immediately go off the rails if we adopt the approach related there, suggested there. And in that regard, Judge, you would have seen that what is further developed by our colleagues on the test is that they say that no court of appeal, and here they quote the 74-year-old, trot out the 74-year-old warhorse of Rex versus Glumayo from 1948, and they say a court of appeal is not going to interfere with the judge who's had the opportunity of observing personalities and demeanor. They say in paragraph 15 that the judgment found in favor of the respondents on every score of the debate, that is the admissibility and credibility of each of its witnesses. Judge, you accepted the evidence. You made no findings on demeanor. You made no findings on credibility in the sense of finding that any of the witnesses were not credible. What you did was to make findings as to what was admissible as regards to expert evidence, and you made findings in relation to the probative value. But this is again an over-energetic attempt to push the case into an area which makes it appeal-proof. It's not a question of credibility findings, so again, that falls flat. So, Judge, I then turn to the issue of if the test is, as we say it is on the SCA basis, a sound and rational basis, there are the two songs. Now, in relation to the position which arises, I would like to answer your question by asking you to have regard most simply to the reformulated Kwalani test, which you find, of course, in your own judgment at case lines 32, your paragraph 88. And I would like, if I may, on typed pages 32 and case lines page 32, this is what we've got to ask in relation to those chants. Subject to the proviso in section 12, no person may publish, propagate, advocate, or communicate words. I pause to say that, Judge, you found, and it's not beyond any debate, that there was communication of words. And then comes the second part, that are based on one or more of the prohibited grounds. The Judge, we say that there is a sound and rational basis to contend that another court would hold that you were wrong to say that there was a deficiency of proof in this regard. There was more oral evidence than there should have been. On the approach which I adopt in presenting this, my approach would be that the oral evidence, as we've said in our submissions, is secondary. What matters is to look at the words and to ask those words, are they based on one or more of the prohibited grounds? So you take the word which is used, and we've given other examples, a word like morphe or sodomite or children of Israel, Zionists, something like that, and you ask, this word where it is used in this context, is it based on one or more of the prohibited grounds? And we say that here another court may hold, as Justice Lamont did in the previous round, that there can be no doubt that the reference to Boer means to an ethnic group in South Africa derived from a history and which has continued to manifest itself and to be known as Afrikaners. So then we carry on to the third requirement, against that person. And then we hit this important aspect, which takes us into your finding about a failure to prove harm. That could reasonably, or first of all, the interpretation, that could reasonably be construed. Now, Judge, could we just pause there? The approach which you adopted was to say, accepting what in fact Mr. Malema and Professor Gunnar argued, and I use the word argued advisedly because they argued, constituted a literal meaning. Now, they also, as you know, testified and you accepted that in the phrase that you used twice in your judgment, in paragraph, I think it's 104, as to what Mr. Malema insisted was meant by the words. Our point is it's not for him to insist, not for Mr. Roots to insist. It's an objective test as to words could reasonably be construed to demonstrate a clear intention to be harmful. What does that mean? It means if you have the objective, reasonable onlooker who says, now, watch this video and hear and know the admitted kill-kiss connection. Look at the gesture which is used with it of the gun, and look at the target, the prohibited ground, which is identifying people who carry one of the 17 stigmata of race, ethnicity, religion, sexual orientation, or the Wyden thing. What does the reasonable person hold that? What could it reasonably be construed as? It could be construed metaphorically, as Professor Gunnar would like it. It could be construed as meaning this is an attack either on the past order, the apartheid order. It could mean, as Mr. Malema would like now to have it, that it is an attack on the failures of the current government. But the question is not what they think. It's whether it could, not would, could reasonably be construed as demonstrating a clear intention to be harmful. And here there are no mealy-mouthed words. It's kill and burn. And it is a target group which is one of the falls within the prohibited grounds. So this is not one of those cases like I give the example, which I'm sure, Judge, you and I both learned at school with Julius Caesar, where cunning words are used with nuances, and the audience knows that if you refer to people as snakes or cockroaches, you may be talking about taking a weapon to a snake or a cockroach, what you are saying. If you mention the group, and if you mention an act of violence, the answer becomes so much simpler. It is kill or burn the booze. And then the question is, Mr. Malema may be right on his interpretation. He may be right that he didn't intend it literally. It's not the question. The question is whether could it reasonably be construed as demonstrating an intention. So, Judge, we say these are difficult interpretational issues, and we respect the fact that you grappled at some considerable length in the judgment with your understanding of what the witnesses were conveying. What we are submitting to you is that if we go back to that initial test, then it's apparent on both songs that, in fact, those criteria are met. Going back to your earliest question to me about little was said or done in the hearing itself regarding the second song, well, that's unfortunate. But of course, when it comes to the judicial conclusion that it is or it isn't hate speech, then it is a matter for the court to go through the exercise of examining the Kwelani Section 10 reformulation and asking how that relates to the second song. And if we look at paragraph 59 of your judgment, we know what happened, because your approach there was very simply that Mr. Krause's evidence was of no probative value. And I leave that aside for one moment, because I don't, the approach we adopt is that a million witnesses saying something in this case wouldn't really help matters much one way or the other. You go on to say his evidence is of no probative value. There is no other evidence presented to show the harm that arose and may arise from the singing of the second song. We say that there's a sound and reasonable basis to contend that another court would hold no, that the harm does not have to be shown that it has arisen or may arise. If we go back to that formulation in Kwalani quoted in paragraph 88 of your judgment, the whole point of the provision is to prevent harm arising. And as Kwalani uses it in paragraph 81 of Kwalani, the provision is intended to aim at the risk of it happening. So one does not have to produce.
But sorry, Mr. Gauntlet, in seeking to prevent the harm, surely the court is enjoined to look at various factors that goes with the definition of hate speech. Now, one of those elements would be identifiable group or persons that may be affected by that speech. Now, in the case of the first song, surely evidence was quite critical, because I don't recall, and I'll have to relook at my judgment, whether there was any reference to the word boer or farmer. It wasn't. How do we
say? I'm sorry, Judge. I apologize. When you say first song, are you referring to the Burn song?
The Burn song, yes.
No, it was Burn the Boers, as I recall in the lyrics. In the, I think it's in the.
No, it says bring the fire brigade.
Fire brigade.
There's going to be fire, and that's as far as maybe I should go to the judgment itself. I think I did quote that. So as far as I could see, there is no identifiable group like, as you say in the second song.
Well, Judge, I'm now looking for the words, and if my attorneys who are listening have the paragraph in the judgment, they would be kind enough to WhatsApp me the particular paragraph. But I have it, that the second line, I remember reading it, has it burn the Boers. And I'm trying to find out now where I've read that.
Noctula, do you have the hard copy? I seem to also be battling to navigate my case line this morning.
Yes, assist the court, Judge. My learned friend is correct. You can find the reference at paragraph 54 of the judgment.
Oh, yes, thank you so much.
Thank you, Mr.
So much.
Kasiboto, thank you.
Thank you.
I owe him a lunch, Judge. Yes, if you look, you will see in the second line.
It does say Lamabun, yes.
So, Judge, there you have it. And your question actually goes to highlight exactly why, if you then go back to your quotation from the Kwalani reformulated section 10, why common sense and legal principle mean that one can't sing a song like this in this context. And let me be clear about that. It would be an interesting case if there were struggle veterans who were gathered in a private meeting, recalling the days, recalling their war songs. Perhaps you remember, Judge, at school, many of us, I think across the spectrum, used to sing the American Civil War hymn, the Battle Hymn of the Republic, which has those lines in about bring forth the terrible swift sword. It depends, these things do depend on where you sing it. But if it's in the context we know, the context in the videos, then it's not that context. And so here you have, in a public context, it being sung, burn these booths. We say that there's a reasonable prospect, a sound basis to contend that another court would say, no, no, the burn is so clear and so emphatic. It's an act of harm. It isn't something, and Professor Gunner, for example, had used the interesting other example of beat Mr. Zuma or beat Mr. Zuma's government. Beat, we know, carries various meanings. You can beat people at soccer. You can, not that South Africa ever does, but you can use it metaphorically. You can use it literally. What you have here is something which could reasonably be construed as meaning burn, put fire to, destroy.
Thank you, Mr.
So, Judge, that is, your question really takes us to the heart of the matter that, number one, the test has to be reasonable. Number two, the emphasis in the judgment about what Mr. Malema intended and what Professor Gunner herself sees as an interpretation of the song is not determinative. Each may be right for themselves. In the University of the Witwatersrand or in the ranks of the EFF, there may be a genuinely held belief that this is the meaning conveyed to those people. But those people do not determine what the court would say, what meaning could reasonably be construed. So the could reasonably means it may happen, but reasonably means it can't be some sort of fringe way out interpretation. So it objectifies it. And then the third aspect, Judge, which we argued in our papers, is that with respect, we must be right that, as I've shown in your paragraph 59 dealing with the burn song, that where you say what is dispositive of this is no harm. Now there again, there's a third basis on which the court may say, no, that puts it too high. You don't have to show that. This is all about risk, as Kwalani paragraph 81 says. And what it's done, intends to do, is to prevent a risk of something happening. So may I give an example? If in South Africa, the language is used about burn the lesbians, burn the Jews, you would not have to show, we submit, that lesbians in fact have been burnt, have been killed. You would simply, going back to the formulation, say that these words demonstrate an intent to incite, and the words are demonstrating the intent. So you can't have the speaker of the words saying, but I didn't intend that. The answer would be, unfortunately, the words you used could reasonably be construed as demonstrating that. And once that happens, it's game over. Then you're not allowed to use those words. You can't say that they kill the morphies and say, well, you know, for me, I think morphe means a morphlam. It's a small sheep. No, it will be said it's one of the prohibited grounds, objectively viewed, in South Africa, in the volksmond, on the tongue of the people. Morphe carries a meaning. So, Judge, that in a nutshell really is my argument. And if I might just summarize it, then we say, number one, as you accepted, but with respect in the end didn't apply fully, the approach has to be objective. Secondly, it's as to what could reasonably be interpreted. Thirdly, with respect, another court, there's a sound and rational basis that another court would say, this is not complicated as regards the boer point. Boer, like Jew, conveys a meaning. It is a protected term in terms of Section 10. It's one of the 17 ethnic, not per se, but it's ethnicity is one of the grounds. You can't do that. Is there that which demonstrates an intent to incite harm? Yes, because you're using a word like burn and using a word like kill. And a person, this objective person who may come in from another part of the country, may not be Afrikaans, it may be from outside the country. Given these facts, as in the law of defamation, the test is, could it reasonably be interpreted as that? The answer with respect has to be, yes, it could reasonably be interpreted as that. The moment it could reasonably be interpreted as that, the special meaning, which Mr. Malemet testifies that he wants to give to it because he was taught what its specialized meaning should be, that is not the objective meaning of the words. And then,
but that argument then, Mr. Gauntlet, as I understand, and the examples that you've given about the veterans and songs being sung at the entrance to the Vets University, it seems to me that it accepts that every time these matters are before the court would have to determine them on the basis of each of their circumstances. It's not like, as I understand, and you may help me here, as I understand, it's the Equality Act doesn't serve like your publication board, where you say the song is unlawful and it therefore banned. And therefore, every time the song gets sung under the publication board authority, it then means you're committing an offense because you're singing a song that is banned. Whereas here, it seems to me, even from your argument, the court would have to look at the time, the facts, the circumstance in which it was sung. You referred to the veterans. If the veterans were to get together and simply say, we now want to relive our history, we want to, this is like the day we've just come out of, Heritage Day, we're now reminding ourselves what happened wherever we were in engaging in the struggle. That may not necessarily mean that it's prohibited. So prohibition has to be looked at much closer in terms of the facts and the circumstances and what was conveyed.
Yes, with respect, absolutely, Judge. In this sense that, as I said, if you have a closed meeting of the veterans who are reliving the Wankie campaign led by Mr. Hani, for instance, in 1968, and at that meeting, in that context, they are singing amongst themselves this song, then that would be a circumstance in which, if you go through all the factors in which it is sung, that the court would hold that this does not constitute hate speech. And you know why, Judge? Because it would be quite clear that it could not reasonably be construed as demonstrating an intent to incite harm in the singing of that song by those 80-year-old men and women. That's the difference. They would be recalling the times of the Wankie campaign. They would not be in circumstances where anybody heard them could reasonably understand that in these circumstances, these men and women are inciting others now to go and burn Boers or kill Boers. Very different if it's outside a court or in a public meeting as part of political discourse. And part of the circumstances is exactly, and this comes back to bite Mr. Malema and Professor Gunner, that they're talking about it in wider society. They say if you do it in South Africa on the steps of Wits or outside the magistrate's court, that's fine, because this is what it means. They miss the fact they don't read the section. The section is not what you think it means. It means whether objectively it could be read, understood by others in those circumstances while you're waving a gun, as you are.
Okay,
that it
thank
means.
you.
So that is the difference. But Judge Mayer, your question is very important, because as so often in law, as you, Judge, no doubt many times have found something negligent or not negligent, you're applying a principle. You're applying it in the circumstances of a case. And what is implicit in what I'm arguing now is that this is not the answer that should come out of this case, should not shut a door on singing of this kind of song in circumstances which could not reasonably be understood to be inciting hurt or harm. Just the same way in a church, if they sing the Battle Hymn of the Republic, or a group of white veterans of the Angolan War sing some of their songs, which had terrible lyrics about killing Nuyoma, if they do that in commemorating their dead, you and I might think that's in bad taste. But the point about it, if they are doing it internally, and somebody looks at them and says, are these 80-year-old people with white hair and on sticks and Zimmer frames, are they inciting harm? And the answer would be, nah, they're not doing that. It can't reasonably be understood. So what you would, or another court given the chance, would actually helpfully decide is that there's not one size fits all answer, but that in the circumstances of this matter, it was shown there was a prohibited ground, there were the kill and burn words, the Boers were identified, and that in those circumstances, it could reasonably, by someone else, not Professor Gunner being a professor and telling us, nor Mr. Malema, what it means. May I then wrap up with your permission, Judge? And that is, in our written submissions, we point to other factors. For instance, the issue of dealing with what we call Afriforum 1, and saying that with great respect, it was not a basis. Another court put it this way, would find it's a sound and rational basis to say that in this division, there is another judgment which deals with this section, true, as you point out, pre-amended, as it were, pre-amended by the Constitutional Court. But it did not cease to be a precedent for the two reasons that you gave. One is that the parties extinguished the order. That doesn't matter. There are many instances where courts hand down judgments and afterwards the parties give up the order. They settle the order. The judgment as the speaking of the court is a separate thing. It has precedental effect. And sorry, Judge?
I agree with you, Mr. Gauntlet, on that. Sorry to interrupt you, but I think it's quite an important point. Because you've just made a point to say the court should not close the door to the singing of the song. And the debate we've just had now, that the court ruling that a speech is prohibited, it's not the same as saying this speech is forever banned. In other words, once the court makes a pronouncement, it doesn't seem to me, and in the context of what we're dealing with now, it doesn't seem to be that the song is now banned and therefore cannot be sung. It seems to me that the parties may still be entitled to come back to a court and say, look, they have sung the song, which is prohibited. And therefore, the finding, and I'll use my judgment, the finding I've made in my judgment would not bind another court if tomorrow, and again, let's take EFF goes and sing the song. Let's use an extreme example. They go and sing the song in the middle of somewhere else, and people are agitated, and the circumstances there are such that it indicates that now we're in the mood of attacking. It really, we're now dealing no longer so much with the risk that's envisaged in the law to protect. We're now dealing with going beyond even the risk itself, that court cannot then be said you are bound by the Molatlehi judgment, because the court will say, no, look, in the Molatlehi judgment, the song was sung in Senegal. Now the song is sung here, where people are now even armed in spears and guns, and the gesture of guns may actually insinuate that we are ready to attack.
Judge, with respect, I must ask you not to get me wrong, as it were. I'm not suggesting that your judgment or Judge Lamont's judgment could be treated as a cutout, a cookie cutout, which is dispositive of every case involving the instance of singing Kill the Boer. The effect of precedent, though, relates not to outcome, it relates to the legal reasoning. And Judge Lamont went through each of these steps on prohibited ground, on could, and third step, reasonably be construed. And he applied the interpretation, which we respectfully submit is the correct one, the fully objective one, not the one which with respect was adopted here, which was to say that I'm analyzing the evidence, I accept the EFF evidence, I accept they didn't intend this, turning then to the law and saying, well, Kulani says objective, but then holding that because the evidence has been accepted and you return in the judgment a second time to the evidence, on the evidence of Gunner and Mr. Malema, that in these circumstances, the Section 10 is not triggered. It must be understood, Judge, what is a precedent? A precedent, to repeat, is not who won or lost, which may well be determined by different factual circumstances. The Sanef case is a precedent, not a cookie cutter. Kwelani is a pet precedent by a higher court, not a cookie cutter. And it's always open to a judge to say, well, in Kwelani, the words about gays were said in Uganda or wherever they were said. Here it's said in this context. But the legal reasoning, the analysis of the provisions in Kwelani, they bind. And so that is the submission that we make, that with great respect, there is clearly a sound and rational basis, and I don't have to persuade you, fortunately, that you're wrong, but a sound and rational basis for another court to hold, that you could not just push to one side, as you did the Lamont judgment. There were things in the Lamont judgment you should have grappled with. So that is our submission on that. And then, Judge, what we submit with great respect was the misdirection concerning following what Justice Molefe interpreted as what Justice Sutherland said. And that goes to 2 points which I can make quickly. One is that another court may hold us right in that regard, that Justice Molefe did not get what Justice Sutherland was saying entirely correctly. And you, obviously in absolute good faith, followed what Justice Molefe was saying. Now, that points then to the second factor, and that it is, although I venture to say, you and I, Judge, agree that there can't be a cookie cutter, there can't be one answer for all cases, that there are these differing judgments which are like lights thrown onto the field, and in certain ways they contradict as regards the lower courts. So we say that is what gives rise to the compelling considerations. The other leg, which our learned friend rightly apprehends, is a reason to grant leave. It really is an important topic, as you show in your judgment. This intersection between freedom of speech and issues of dignity and freedom from violence. These are fundamental in our lives. And this, with respect, is a case where, although there will not be one single answer, as Kwelani is not one single answer, Kwelani does not answer for all time what you can say about homosexuality. Just like in any defamation case, it doesn't answer for all time. when you can say somebody's a crook and when you can't say there's a crook without it being defamation. So we respectfully submit, to sum up, that if we are correct, and we venture to submit we must be, that the SCA test on leave to appeal is simply sound and rational basis. It's not a certainty. That's putting it too high. Secondly, that we have advanced what we submit are sound and rational bases on 4 or 5 points, which we know caused you difficulty, would cause anybody difficulty in the determination of this matter. And we respectfully submit that on any one of those, another court might differ. And thirdly, we submit that there are compelling considerations why this case, involving as it does freedom of speech and political activity, and also on the other hand, public safety, why it should go further. And it's for those reasons, Judge, that we would ask that if you are with us, that you would grant leave to the Supreme Court of Appeal as clearly meriting its attention.
Thank you very much.
Thank you, Judge.
Thank you, Mr. Gauntlet. In answer, Mr. Kasiboto.
Thank you, Judge. I'll take my cue from your invitation earlier, which was a sense of comfort that you've gone through our heads of argument, and really they speak for themselves. And I do not intend to go back to the heads. In fact, the entirety of my address to you will be in response to my learned friend's oral submissions. And let me start here, Your Lordship. The issue about what the applicable test is, really, as far as we understand it, is neither here nor there, at least as far as the dispute is concerned. And we make the submission on the simple premise that what you find as reference to paragraph 7 of S versus Smith, which is the proposed test, it is extracts of a fuller paragraph. Our submission is, once you have reference to the entirety of that paragraph 7, then you've got a test we respectfully submit that is analogous to the one you've provided to court. That's the first submission. The second submission is this. As we understand S versus Smith, it is a decision that came about prior to the amendment of the Superior Courts Act. Of course, my Lord would be fully aware that the test has changed sometime in 2013 or thereabout. And the test and the threshold for leave to appeal has accordingly changed. It is for that reason we rely on a decision of this province on what the test is for Section 17 prospects of success, i.e. Roman numeral 1 of Section 17. And once then you have reference to what the word would means, as interpreted by this division, you get to the word certainty, because it is a decision of this province that incorporates the word certainty in interpreting what would come to a different conclusion means. So, I mean, I do not want to belabor the point. Our heads speak for themselves in that respect. The second point of contention, Your Lordship, is the question of what the word boer means. With respect, for the first time today, we're told what meaning the applicant gives to the word boer. And we hear it for the first time in an application for leave to appeal. You will have reference to the entirety of the record of the trial process. Nowhere will you find a meaning of what boer means from the applicant's version. It's an important point, Your Lordship, because it is, if you will, the pivot the entirety of this case stands or falls on. What you have, and we've made reference to it in our heads of argument, is a version that is given by an expert of what boer means. And I'll tell you shortly why that matters in reference to Masuku's decision. The expert that is called by the applicant, when the question is put, what does boer mean? He says, It either means farmer or Afrikaner. Takes the point no further. That is the entirety of the version that you're given by the applicant as to what the word Boer means. My learned friend, for the first time today, gives us an election of which of the two you must prefer, without substantiating with respect either than to merely make reference to Judge Lamont's decision. And we've dealt with why you're not bound by his decision with respect. But now let's run with that argument. So there's that fatal flaw of we actually have not received any evidence as to what it means, either than my learned friend's first, for the very first time, version of which of the two words you must prefer, two interpretations you must prefer. But the context in itself, Your Lordship, tells you what the word Boer means. It suggests that the context is in the words of the song itself. The lyrics of the song are, kill or kiss, whichever version you take, the Boer. Kiss or kill, the farmer. Interchangeable use of language for the same idea. Kill the Boer, Afrikaans reference. Kill the farmer, English reference. That's the context. Secondly, Your Lordship, the evidence led by the applicant, a sum total of 5 witnesses, 3 experts, 2 lay witnesses. All of them led evidence about farmer tax. That to me means, that's the interpretation of what that's the interpretation they give to the words kill the Boer / kiss the Boer, kiss the farmer. Their own evidence was not premised on attacks on Afrikaners per se. They were attacks on farmers. They have not run with an argument as to why or how farmer is a prohibited ground. If anything, my learned friend tells us it actually means Afrikaner. And that is the difficulty that belies the version or the submissions on behalf of the applicant with respect. What is equally crucial, Your Lordship, is this question about subjective intentions, expert witnesses, subjective views. We make reference, Your Lordship, in our heads of argument, paragraph 57. And paragraph 57 is reference to what the Constitutional Court in Masuku held. What the court held there is, it was impermissible, if I can find it. In essence, you find it in paragraph 57 of our heads of argument. I've been moving paper around. I have now lost myself. The essence of what the court says there is, it was incorrect of the lower court to say experts have got no role to play in such hearings. And it's really important that I quote them verbatim because a lot turns on this. The essence of the finding is, in hate speech matters where there are nuances about language and meaning, of course you allow experts to give an interpretation. You'll recall, Your Lordship, that in that debate, in that dispute, the question was what the word Zionist means, what the word Jew means. The court is not equipped to make that determination. Context matters outside of the competence of the courts. For that reason, they accept the testimony of experts. Similarly here, there's a fundamental dispute about the meaning of the words kiss the Boer, precisely because the word Boer, I'll submit, is not as straightforward as our learned friend seems to suggest to this court. For that reason, of course, then, you must have the benefit of an expert in culture and in song to assist you with the meaning of the word Boer in that particular context. So with respect, you can't have the applicant approbate, then reprobate the principle of what an expert is and what role they play. They can't call witnesses to give you context in the same breath say discard the evidence, expert witness, the evidence of the expert witness called by the respondent. I really implore your lordship to have reference to that paragraph 57 of Masuku at paragraph 145 of that judgment. And my suggestion, your lordship, is this. For the same reason, you did not accept that a prohibited ground was established, because the contention seems to be the prohibited ground is Boer, which my learned friend translates to Afrikaner. In the same way, so the point is this, there's an overlap between the first song and the second song as far as the prohibited ground is concerned, the word Boer. Now, if you can't, as a matter of logic, find that Boer is a prohibited ground in relation to the first song, it must follow as a matter of logic, it can't be a prohibited ground in terms of the second song. Why? Because you have never been given a controverting version of what the word Boer means. What the respondents have done is give you a meaning and context to the word Boer. What comes from the applicant is, well, Boer means one of two things, but do not peg their case on either of them. One, conceivably, yes, a prohibited ground. The other, not a prohibited ground. And you have to make an election. How do you make an election? On the balance of probabilities of the evidence that is put before you from an expert, which Masuku says, whose evidence you can hear. Moving to the third last point. Of course, the test is that of reasonability and objectivity. But reasonableness of what? You are assessing whether the communicator of the words had a clear intention. That's an important aspect of the debate that you must bear in mind when you make your decision, your lordship. It is not enough, and we accept that Mr. Malema's subjective view does not matter much, save for to give you context. For the same reason, lay witnesses were called by the applicant to give context to the debate. You must accept Mr. Malema's version to the extent it gives you context, not his subjective intention, but the context to the debate. And this is not new. Same thing has happened in previous cases. Masuku, Kulane, you had witnesses to give context to the debate. There's nothing that is anomalous about that. But what you must ask is, did the communicator of the words have a clear intention? I had a debate with my learned friend who comes before the now learned friend about what the meaning of clear intention is. The meaning of clear intention can be nothing other than a test that is even greater than intention. The threshold is that much higher. So when you objectively assess the evidence before you, you must ask yourself the question, has the applicant discharged the obligation of showing that the communicator of the words had a clear intention, not that the possible outcome of what he says might be, but he must have clearly intended that which is alleged by the applicant? With respect. Penultimate point. There's a fundamental concept that is made by my learned friend on behalf of the applicant, and it is this. There can't be a ban of a song at all times, at all places, for all purposes. There can't be. It's inconceivable. What is the consequence of that fundamental concession? It is this. No other court can come to a conclusion that says, yes, we agree with the applicant at all times, at all places, because that is in essence what they plead, and that is the prayer they seek. It's unqualified. No other court can give them that remedy in light of that concession, which with respect is correctly made. The Supreme Court of Appeal or any other court, full bench, cannot give them the remedy they want. because it seeks to blanketly burn the song. I do not want to belabor the point any further. And that is a fatal error that is committed with respect by the applicant. If I can then make reference, lastly, Your Lordship, to paragraph 13 of our heads of argument, which appears on page 7 of our heads of argument. The debate there is, you pardon me, it's rather their heads of argument at paragraph 13, page 7. You don't have to go there, Your Lordship. But the last sentence is a proposition that what this court did is to draw or seek to draw or find a causal link between the impugned statements and the outcome, the causal link debate. The suggestion is, to the extent you insisted that that causal link must be drawn, you made an error in law which is appealable. With respect, that is not our interpretation of what Your Lordship says and conveys in the judgment. As a starting point, it was the applicant's case that the singing of the song, either one or two, song one or song two, has these consequences. That has been their consistent evidence from witness one to the last witness. To the extent they run that case, and a clear example of that, of course, is these farm burnings, which supposedly were caused by the singing of the song by Dr. Mbuyiseni. In fact, you can have reference from paragraph 33 of our head's argument, where we detail examples of when the causal link was sought to be drawn in respect of both songs. So that's the case they ran. But you take the point further, Your Lordship. You don't leave it at, you failed to show me the causal link. If you go to paragraph 58, you can just make a note of it in the interest of time, Your Lordship. If you go to paragraph 58, you will see what you actually found. Having discussed the question of the causal link and concluded there's no causal link, this is what you say in the last sentence of paragraph 58. I may add that this evidence, i.e., by Mr. Krauser, does not in any manner provide a context upon which it can be said that the song does not deserve protection of free speech. In other words, having dispelled the idea of the causal link, you say, I may add, over and above, concluding that there's no causal link, there is no context I'm given under which I will find that this is hate speech, objectively speaking, that is not deserving of hate speech, rather free speech protection. So, and we make references in our heads of argument of other instances where your finding is not consistent with the suggestion that you deliberately and exclusively sought to see or find a causal link, and to the extent there is none, then it can't be hate speech. Far from it. Lastly, on the question of the gestures of the song, and I think the suggestion is along the lines of, in looking at the song contextually, the first one specifically, kiss/kill the Boer, there is a gesture sign that accompanies the lyrics. We've made the point ad nauseum, particularly in submissions in a trial, that it would take judicial notice of this, Your Lordship. There is no struggle song that is sung at a standstill. Gestures do nothing but add performance. In the same way, they would be hopping and skipping, bending their knees hitting chest when they sing struggle songs. That's performance. Conceptualize an instance where you're singing a song that is meant to evoke and drive an idea and galvanize people, sung in a standstill position. Their gesture is nothing but adding to performance. Similarly, Your Lordship, you found that the singing of the song Letumshini Wam, literally speaking, could well amount to hate speech, but it does it in context. How is that song sung? Letum Shiniwam gesturing an AK-47. It adds performance. It does not in itself give meaning to the song. The analogous proposition is made in respect of the first song. Unless then your lordship has any questions for me, therefore to implore the court to have reference to our heads of argument, which by and large deal with the submissions that were made on behalf of the applicant. I've got no further issues to address to your lordship. Perhaps as a last point, my apologies, your lordship. There's a criticism that we rely on a 74-year-old judgment. Presumably the suggestion is that it is stale law. Of course, it still remains good law. But we also make reference then to another judgment, which is now not as stale as the proposition in respect of Zumayo. And that is a decision that comes from the SCA. It's at case lines 2890.
2890.
Yes, your lordship. If I could just quickly read it in terms of what the applicable test is. And I'm saying it's really a question of wording. Ultimately, they all amount to the same thing. If the appeal court, and I'm reading paragraph 10, there's a preceding paragraph before that. But I just want to focus on this one specifically for now. But of course, in due course, your lordship, you're going to read 2890. And it in fact starts at 2889. It says, if the appeal court is merely left in doubt as to the correctness of the factual conclusions arrived at by the trial court, it will uphold it. The Supreme Court of Appeal in S versus Naidu and others reiterated this principle as follows. In the final analysis, the Court of Appeal does not overturn a trial court's findings of fact unless they are shown to be vitiated by material misdirection or shown by the record to be wrong. So the threshold, whatever the semantical imputation is inferred by each of the various principles we're debating, ultimately the bottom line is the threshold is not what is being proposed with respect by my learned friend. The threshold is much higher. And with respect, your lordship, we then say for those reasons, the application stands to be dismissed with costs. Sorry, final point, I promise, your lordship. We have written to your lordship and we had suggested that there was a clerical error in paragraph 47 of your judgment. And as I understand it, the other side, the applicant was cited, or rather copied in the email. And I don't want to take you there now, your lordship. We are happy to resend it to your lordship to the extent that you are not in possession of it, but I know it was sent to the court. And what you suggest there is there's a clerical error, because when you read paragraph 47, in conjunction with 46 and 48, what you get is there's a word not missing in paragraph 47. I mean, of course, I'll concede that it then changes the context and the meaning of what is being conveyed in the judgment. But we've asked the court to take, you've got inherent jurisdiction to mirror motu, if you will, amend the clerical error, and then make an analysis of this application on the proper reading. The letter speaks for itself. It's quite detailed as to what our contention is. And to the extent your lordship is not inclined to make the decision mirror motu, we of course are prepared to bring a substantive application in that respect.
Okay, thank you very much. In reply, Mr. Gauntlet, and maybe let's deal with that very first point. Yes. I didn't see any, my secretary did bring to my attention this error. I didn't see any response from your client, yes. But I take it it's an obvious error that I could deal with.
Yes, we abide that. We abide that, my lord. So
okay. Thank you very much. I will effect that variation. Thank you. Let's then hear your reply.
It's clear enough where you return to the topic that you make a finding that Mr. Roots is unqualified, and we
Okay.
deal with that. Very briefly, my lord, because we know that we are now into beyond injury time and into other time to which you are committed. Very
Yes.
briefly,
Just give me 1 second. And I don't like when people are waiting and they're not even sure what's happening. Noktula, could you please go and inform people in court that I should be coming in the next 20, 30 minutes? Yes. Okay, thank you very much. I appreciate it. Yes, thank you, Mr.
Thank you, Judge. I'm sorry that you're so much in demand today that you are being bitten from both sides. Judge,
Yes.
may I start with the test? Significantly, our learned friend, in his very lucid analysis, shied away initially from directly grappling. He said, with the test, he said, it's neither here nor there. That is because what he has submitted in his written submissions with respect is quite clearly an overstatement, an over-argument, when he talks there about a certainty which is required. He says in paragraphs 8 and 9, and when he credits to our approach, going on appeal simply because a disgruntled litigant wants another court to have another look. It's not the case at all, my lord. The test is, as I believe he has implicitly accepted, he has not said that it is wrong, that it's a sound and rational basis. What he tries to do is somehow parallel with that, argue for a higher degree of certainty, which can't be so. But let's take him at his word, neither here nor there, for his argument. But then we must look at the consequences of that concession. The first point is this. In granting leave, Judge, we respectfully submit that the core of it is to look at the key Kolani reformulated provision and take the elements one by one. It's in your judgment, and it's in our heads of argument. First thing, you found the communication. Then comes the first major point. He devoted much of his argument to saying we did not show that those words, food, farmer, were based on one or more of the prohibited grounds. Now, Lord, the position we respectfully submit is in fact quite clear, that from the beginning, as he went on to say, through the evidence, it was said that it was understood as a reference to boers or farmers. Farmers is the English translation for boer in one sense, but what is clear is that it could, this is the test, the moment it's accepted that the song refers to boers or farmers, then somebody hearing the boer word could reasonably understand that that means Afrikaners. And that is exactly what Judge Lamont held in paragraphs 4 of his judgment, where he says that it's a matter of history, that in this country, paragraph 4, there's a group of immigrants who banded together. This faction, known as Boers, in the pursuit of freedom, left the community of European settlers. The Boers were able to seize control after the elections in the late 1940s. And so he carries on referring to Boers and to Boere. Secondly, we all live in this country, and that is the reason why in footnote 22, we quote the Grootkraal recent judgment of the SCA, saying that judges don't live in ivory towers, they live in a society, and they know that if there's a reference to Khoisan or Hottentot or whatever a word may be, they know what the derivation is and the setting. But here you also had evidence. So with great respect, to attempt to get out of this case on the basis of saying that there was no evidence before you regarding what boer meant is not true. It was said to be boer or farmer. So within the wider category is boer, and I might say as a matter of judicial notoriety, the overwhelming majority of farmers in this country of white farmers in this country happen to be Boers or Afrikaners. So, with great respect, the respondents should not be playing this game. They know exactly what they mean when they use the word Boer. Thirdly, in that regard, of course, there's a place for experts to testify, as in Masuku, as to the interrelationship between Zionism and Judaism. That is an arcane subject, and not every Jew is a Zionist, and perhaps not every Zionist is a Jew. That is not the point here. That was not the point of what Professor Gunner was doing. Professor Gunner was supporting Mr. Malema on an interpretation that, as she puts it, and as you accepted, as he insisted, it should not be interpreted literally. But that, Judge, is where the misdirection comes, the fundamental misdirection. And that is that it has to be seen objectively. If we go back to that section, as reformulated in Kwelani, communicate words that are based on or one or more of the prohibited grounds, it is. It's a reference to Buddha, to Boers. Boers means Afrikaners. It may mean, in one other sense, when translated into English, farmers, but that brings you right round again, because a substantial part of the farming population are Afrikaners. That could reasonably be construed. And Judge, this is, with respect, why this matter needs to go on appeal. Because there is, with respect, more than a sound basis to construe that, with great respect, what you did was to embrace the evidence, and with it the assertion of Mr. Malema and Professor Gunner as to what they intended. And the question is not that. It's the objective one. In your judgment, with respect, you don't analyze the significance of could, that it could reasonably be construed. The emphasis, the importance of could is, with respect, not developed, not analyzed, and then be construed. And here comes the last point, which our learned friend argued. He said the applicant had to prove an intention to be harmful. No, the applicant didn't. Again, the difficulty with not, with respect, stating and analyzing the amended section 10 early in the judgment before turning to the evidence is that what gets blurred is what has to be shown. And the phrase, again, if the court has it before it, the Kwelani formulation, could reasonably be construed to demonstrate a clear intention to be harmful. It's the words that must demonstrate. Nobody has to bring proof, aliunde, external proof of what Mr. Malema was intending in his head, what reservatio mentalis, what subjective meaning he had. It's the court, the law is concerned with the word that you used. If you refer to somebody as a mofi or a yid or any other of these pejorative, horrible words for people who fall within the prohibited grounds.
I think you made that point earlier, Mr. Gauntlet. Let's move on to the reply.
Move on to the?
I'm saying you have made that point about calling people morphs and whatever. I think you made it in the opening.
I did, but the context in which I make it now, Judge, is very specific, and I'm afraid I must repeat it to that extent. The context is, which I now make it, is this. You have just heard an argument that there was no proof of an intention to harm. I'm saying the inquiry is whether the words reasonably objectively construed, the words demonstrate it. You can have whatever secret intent you like. My point is that and if you use the word burn, and you were concerned that it wasn't there, but we found it, burn the Boers. And if you will use the word kill the Boers, we are over-intellectualizing this case. It's very, very simple. Those words used by any person in any imaginable circumstances, except some highly, highly specialized exceptions are come to, clearly demonstrate intention, etc. Lastly, Judge, is this point about the point that I made about the veterans and about context and the debate which we've had, and my learned friend has picked up on this. In the law of defamation, one gets no judgment from a court that in all circumstances calling a person a crook or something of that nature, that it is defamatory. It is always something which has to be determined in circumstances. Of course, the court's precedental dealing with it is a matter of great significance. The only point I was making is that your judgment and any future court judgment, like that in Kwelani, is not legislative. What it will do is deal with what's before you. And what is before you is a situation where these words were used in these circumstances, and they were not what could be argued for as being some seminar, some closed meeting of old struggle veterans. It was these circumstances, and those circumstances are taken into account. So if a person, a reasonable person, is told this is being said on a public platform, and it's been known, and this is what's emphasized in Malema 1, that of course the media will broadcast it into the world too. In those circumstances, then that does constitute, first of all, the prohibited ground, and that it could reasonably be interpreted as demonstrating a clear intention to be harmful. And lastly, Judge, what does make the contrary argument with respect bizarre is if one tries to explain away the accompanying gesture, which was not assessed and not factored in the judgment, but the accompanying gesture as being of any ordinary kind of toy-toying capacity. If you use that which is an instrument of death symbolically, as we say in our heads, a rope, a knife, a gun, and you're using the word kill, then it is patently something which, whatever you say you think, would reasonably be interpreted as saying, use this, do this. Thank you, Judge. Those are our submissions.
Thank you very much. Thank you, Mr. Gauntlet. Thank you, Mr. Kasiboto. I'm going to reserve judgment in this matter. You will be notified as soon as judgment is ready. Thank you. The court shall adjourn.
Thank you, Judge.
Thank you, Judge.
Thank you very much. Have a nice day.